Welcome to today's Empowered Chat on ensuring I-9 compliance and preparing for an ICE visit. I'm Shanzana Kidston, a manager with Raymond's Risk Advisory Services team, and I'm joined by Elizabeth Williams, principal with Raymond's HR Solutions team. With recent changes to ICE enforcement and I-9 requirements, the stakes for employers have never been higher. Today, we'll talk about what's changed, what it means, and how organizations can be prepared. Elizabeth, thank you so much for joining me today. So the first question I have is, what's changed with ICE and I-9 compliance?
Well, Shanzana, I'll start by saying this. It isn't new, but it's more urgent than it's ever been in a long time. We're seeing significant increase in enforcement. In fact, ICE recently expanded its workforce by over 120%. They added more than 12,000 officers through an unprecedented nationwide recruitment campaign that exceeded expectations. It drew over 220,000 applications. And that signals a clear shift toward broader and more aggressive enforcement activity, both workplace audits and on-site actions. At the same time, what's really changed and what's catching employers off guard is how I-9 errors are being treated. Historically, many mistakes were considered technical on those forms, meaning you had time to fix them. But that's no longer the case in many situations. We're now seeing over 10 of the most common I-9 errors being treated as substantive violations. That means they can trigger immediate fines with the opportunity to fix them after the fact eliminated. Things like missing signatures, missing dates, incomplete sections, or even an outdated form itself. And those fines quickly add up. The current penalty for paperwork violations runs $288 to $2,861 per form, not per organization, per form. If there are repeat or intentional violations, when you're knowingly employing unauthorized workers, that can escalate to over $28,000 per employee. So take the number of employees that you have and multiply it to see your risk potential. And Shazana, I'll tell you this, seldom do I see during an I-9 audit a form that doesn't have at least one error on it. The risk and these fines have a real financial impact to organizations, and employers need to take it seriously and act immediately.
Wow, that is a lot of great information. Can you share a real world example of an organization that wasn't prepared for an ICE audit?
Sure. There's a small Michigan manufacturing company. They have less than 50 employees, and they recently experienced an unanticipated visit from ICE. And what came out of that audit were fines totaling over $45,000. And it was all tied back to inaccuracies and missing information on their I-9 forms. And what's important here to understand is there was no malintent. There was nothing done in malice. They simply didn't have the right processes in place and didn't fully understand what proper I-9 compliance requires. It's one of the many examples we see for how quickly this can become a significant and costly issue. Not because a company is intentionally doing something wrong, but because they didn't know what they didn't know.
Yeah, that sounds like it can cause a very large impact. What happens if ICE actually shows up?
Well, this is where preparation really matters because the worst time to figure it out is when they're knocking at the door, right? So first, it's important to understand most workplaces are private property. ICE cannot enter non-public areas or access records without a valid judicial warrant. And that distinction matters. An administrative warrant is not the same thing. You don't have to let them past the front lobby with an administrative warrant. So if ICE shows up, the response should be calm and structured. Greet them professionally, ask for identification, and document who you're speaking with. Request to see the warrant and immediately escalate in the organization. Bring in HR, call your legal counsel. Here's what shouldn't happen. It's just as important. Don't volunteer information to them. Don't answer questions about any specific employees, and don't grant access without that proper authorization. And that's not being uncooperative, it's following the law, which protects your organization as well as your employees. The key message I always give clients is stay calm, don't consent, and escalate communication immediately to the proper leaders. And one point I'll add in, this is not hypothetical. In Michigan alone, there were over 4,300 ICE-related arrests between early 2025 and 2026. So while audits are more common, enforcement activity is happening.
Yeah, those are some great safeguards to have in place. Why do I-9 audits matter so much right now?
Well, most ICE enforcement actually starts with paperwork, not a raid. Employers are required to produce I-9 documentation within 3 business days of receiving a notice of inspection. That's not a lot of time if your records aren't organized and complete. And with the recent changes eliminating the cure period for many errors, you don't get the second chance to fix it after the fact. That's why proactive I-9 audits are so critical. They allow organizations to catch and correct errors early. They ensure that they're using the correct form and processes, and they reduce risk before ICE ever gets involved. It's about minimizing disruption to your organization. When I-9s are clean, organized, and accessible, it protects not just the business, but employees as well. I always say this is one of those areas where a relatively small investment in time up front can prevent significant financial and operational impact later.
Thanks for that information as well. What should employers be doing now to be prepared?
Well, there are a few foundational steps every organization should be taking right now. First, conduct an internal I-9 audit or have a third party do it. That helps to ensure corrections are handled properly and in some cases under attorney-client privilege. Second, designate clear ownership. Someone needs to be accountable for I-9 compliance, and this can't stay living in a gray area. Third, evaluate your processes. Are you using the most current I-9 form? Are your electronic systems compliant with ICE standards? Are your remote verification practices consistent and documented? Fourth, train your team, HR, managers, and even the front desk. They need to know both how to complete I-9s correctly and what to do if ICE shows up. And finally, have a plan, a simple documented ICE response protocol, who to call, what to do, what not to do. It goes a long way in reducing risk and confusion in the moment. It's really about moving from reactive to being proactive.
Elizabeth, thank you. This was such a helpful conversation. If there's one takeaway, it's this: preparedness matters. Conduct an I-9 audit to ensure you have the right processes and documentation in place. If you're not sure where to start or would like a second set of eyes on your I-9 compliance, don't hesitate to reach out to Raymond. We're happy to help. Thanks to everyone for joining us, and we look forward to continuing the conversation.